We will no longer be designated a letter of the alphabet. We will no longer declare we are 11A, J or even K, and no one will hang their heads in the shame of being non-qualified. From now on, everyone that lives in Jersey will fall into one of four categories: entitled, licensed, entitled to work only, or registered. For those of us that have completed 10 years continuous residency in the island, we will be classed as entitled. Similarly, anyone that is a 11K will also be classed as entitled. An entitled person may purchase or lease any residential property in the island. They may start up a business and work for any employer. What will no longer be immediately apparent is how that person has the ability to be entitled, because, as I said, we no longer have the alphabetical designation. However, depending upon how a person has become entitled, they may be permanently entitled, or they may, in certain circumstances, lose their entitled status. A Jersey-born resident who has completed 10 years aggregate residency will be permanently entitled and cannot have their entitled status taken away however long they leave the island for. A non-Jersey-born resident who arrived in the island before their 16th birthday and has completed a continuous period of 10 years residency will be permanently entitled. This particular route of gaining your entitled status is new under the current new compared to the current situation. It has been introduced to assist those residents who did not choose to come to Jersey but were brought here by their parents. Similarly, a person will be permanently entitled if they arrived in Jersey before their 20th birthday, complete 10 years aggregate residency before their 40th birthday, and importantly, they have a parent who is entitled to live in Jersey. If a resident has entitled status through what was previously 11K, they can elect, upon completing 10 years continuous residency, to change their entitled status from being linked to their 11K status to being linked to their continuous status. The benefit for somebody in doing this is if their financial circumstances significantly change so that they no longer meet the 11K criteria, they will not lose their residential status in the island and can continue to live here. Any residential person granted a hardship status will be entitled. Their entitled status will be subject to any restrictions the Chief Minister wishes to impose on them, and would normally include absences from the island leading to them losing their entitled status. We do not believe it is envisaged that the criteria for hardship applications will change under the new regime. In a change to the current position, a non-Jersey-born person who arrived in the island and qualified through 10 years residency can lose their residential status if they leave the island for a period or periods which aggregate to more than 5 years. The change here is the total period of absences are aggregated rather than under the 1970 regulations, where the number of absences would lead to them losing their residential status. This is much fairer than under the existing regime. A person who has 30 years residency, whether they are Jersey-born or not, will be permanently entitled despite future periods of absence. They have obviously shown a very big commitment to the island and are rewarded with permanent residency. A licensed employee is the equivalent of a J category employee. They must be essentially employed, and their employer must hold the appropriate business licence confirming that they may employ them. A licensed employee may lease property, or they may buy property and live in it whilst they continue to be essentially employed. The Minister has the power to put conditions upon the employer's licence with regard to property ownership. So whether a licensed employee can purchase property or not will depend upon the terms of their employer's licence. Historically, if a J category employee wished to purchase property, they had to set up a company and purchase the property through that company. And then upon completion of 10 years residency, if they chose to stay in the island, they would need to transfer the property from their company into their own name. Under the new proposal, a licensed employee will be able to purchase the property in their own name at the outset. This will clearly give them a saving in stamp duty and legal fees if they choose to stay in the island for a 10-year period. It will continue to be the case that a licensed employee's spouse or civil partner may join them in their purchase. The new law will also do away with the requirement that a J category employee, now licensed, purchasing through a share transfer structure, had to lease their property to their employer and then be licensed by the employer to occupy the property. They will now be able to reside in that property in their own right. It should be noted, however, that despite the change how licensed people may own property, it will remain a requirement that should they lose their licensed status, that they must vacate the property and, if they own it, place it on the market for sale. A licensed resident loses their licensed status if they become entitled through 10 years residency, and as I said, they can then continue to own the property in their own name. It does not become a trigger for them to sell the house because they are no longer licensed, they are entitled. A person is entitled to work only if they have been continuously resident in Jersey for a 5-year period. They can also be entitled to work only if they are married to someone who is classed as entitled, is licensed, or is entitled to work only. Being entitled to work, as the name suggests, means that they are able to work for any employer. A person who is entitled to work may rent property which is registered with the Population Office as suitable for people that have their designation, and my colleague Andrew Pym will be talking about that in more detail in a moment. As we heard from John Webster, a person entering Jersey is required to register within 3 months of arrival. Until that person has been continuously resident in the island for 5 years, they are classed as registered. There are restrictions on where they can work, and employers will be limited to the number of registered employees they can employ. A person holding registered status is the equivalent to the non-qualified status, and there will be similar restrictions upon where they can live.